Hello, I'm Eric Rudolph. I'm an estate planning attorney who specializes in estate planning for same-sex couples. On June 26, 2013, the United States Supreme Court ruled in United States v. Windsor that DOMA is unconstitutional. As a result, same-sex couples like you can now plan your estate in a whole new direction. This landmark decision means there are now new estate planning and tax planning opportunities for same-sex married couples. Same-sex couples who are legally married now enjoy marital recognition at the federal level, Social Security survivorship benefits, joint tax return filing, and estate planning benefits. With proper planning, same-sex couples can now create an estate plan that provides for both spouses during their joint lifetime, provides for and protects assets for the surviving same-sex spouse, and assures their assets will go to family, friends, or charities of their choice after they both pass away. Important estate planning issues that same-sex married couples need to know: eligibility for the estate tax marital deduction, portability, transfers between same-sex spouses are not subject to federal gift tax, gifting to someone other than your same-sex spouse, and IRA rollover rights for same-sex spouses. Eligibility for the estate tax marital deduction. Now, same-sex married couples can defer federal estate taxes when the first same-sex spouse dies. Because the federal benefit now applies to same-sex couples, assets that may be subject to a 40% taxation rate can be protected with proper estate planning, including disclaimers and a bypass trust. Portability is the ability of the surviving same-sex spouse to add any unused estate tax exclusion of the deceased spouse to his or her own. The surviving spouse will transfer the unused exclusion amount of the deceased spouse to him or herself and can then use it to make lifetime gifts or pass assets through his or her own estate with a greater federal estate tax exclusion amount. Same-sex spouses can now transfer an unlimited amount of property between each other without being subject to the federal gift tax. Prior to DOMA being repealed, even the purchase of a car for a same-sex spouse or adding the name of a same-sex spouse to a real property deed previously triggered a gift tax. Now, same-sex married couples can transfer any amount of money or property between each other with no federal gift tax consequence. Currently, you can gift up to $14,000 each year to any individual without incurring a gift tax. Now, same-sex spouses can combine their annual exclusion to jointly give $28,000 to any one person, gift tax-free. For IRAs and qualified retirement plans, the law gives special privileges to spouses who inherit these funds. Unlike other beneficiaries who must begin making withdrawals by December 31st of the year following the account owner's death, a same-sex spouse who inherits an IRA or company retirement plan has other options. The same-sex spouse can now elect to roll the assets into his or her own IRA and postpone required minimum distributions until the year after she or he turns 70 and a half, allowing the money to remain in their account, accruing tax-deferred growth. When same-sex married couples have one marital trust, the surviving spouse does not have to go through a formal trust administration of the same-sex spouse's estate because everything is held in their one marital trust. Prior to DOMA being repealed, same-sex couples could not benefit from marital trust with a disclaimer trust or bypass provision, and they usually elected to have separate trusts that named each other as their primary beneficiary. This required the surviving partner, or the person named as successor trustee, which is usually the surviving partner, to handle a full-blown administration of the deceased partner's estate. Now that same-sex couples who marry are considered spouses, they can have one marital trust, and the assets can just remain in the marital trust for the benefit of the surviving spouse, with their surviving spouse as beneficiary and sole trustee. This eases the burden on the surviving same-sex spouse at a time that is already difficult enough. Same-sex couples who get married, or who were already married in a state or country that recognized same-sex marriage before DOMA was struck down, should have their estate plans reviewed and analyzed based on the new changes in the law. Going forward, when planning the estate of married same-sex couples in California, a marital trust is likely the best choice. For more information on estate planning, please visit my website at www.rudolphlegal.com. Thank you for watching my video.